Today, it's my pleasure to welcome Nikolaus Forgo from the University of Vienna, and I'm very happy that he's joining us today. This is the first, by the way, of a series of sessions to do more with the legal aspects of algorithms or algorithmic governance. Nikolaus is professor of IT and IP law, and he is head of the Department of Innovation and Digitalization in Law. He's also, by the way, co-chair together with Barbara Preins of our research platform, Governance of Digital Practices, which organizes or hosts this lecture series. Nikolaus has published widely on issues to do with data protection, privacy, IT regulation, intellectual property, innovation in tech, and also legal innovation, and generally the law and technological change. He's also a regular and, may I say, increasingly regular and very much in-demand contributor to public discourse. He's got a very interesting and active podcast series called Ars Boni, which we promoted already in the first session in this lecture series. He's also a regular contributor to news media and has sort of various interventions going on there. Today, Nikolaus will speak about the law of algorithms, and as usual, the structure is that he'll have his input and we'll have a Q&A towards the end of the session, so you'll have a chance to ask questions in the last sort of third of the session. And that's it from my part. Nikolaus, thanks very much for joining us today, and over to you. The floor is yours.
Thank you, Lucas, for the kind invitation and also for the introduction. I'm one of the very few lawyers in this class, as far as I know. So let me be very brief in introducing the department I work for. We are a legal department. Many of the people at the department, not all of them, but many of them are lawyers, including me. I have been working, however, for the last 30 years or so on the interplay between information technology and law. So I do have some computer science expertise. I wouldn't call it background, but at least expertise. And this is also what I'm doing in this department. I'm trying to work on the relation between computers on the one hand and the law on the other hand, which is very challenging for many reasons, and I will come back to many of them later during this, roughly speaking, 1-hour presentation. I think if you talk about our topic today from a legal perspective, you can't do this, and that's probably already the first message to all the non-lawyers in the room. You can't do this without talking about the European Union. So the interesting one of the interesting phenomenons of my field of expertise is that, different from other legal domains, such as administrative law or constitutional law or private law, this is a domain that is no longer nationally planned and configured, but it's a European thing, and it's a European approach. So we have a kind of joint, at least in theory, I will come into the details, we have a kind of joint European approach to many, if not all, the issues I'm talking about here. So talking about this field is also talking about the European Union, at least from a European perspective. And when you're talking about the European Union from a legal perspective, there is a distinction that needs to be made between what lawyers call primary law, what lawyers call secondary law, and what lawyers call case law. And all three foundations are important here. So primary law from a European perspective means, in particular, apart from the treaties, which are the fundaments of the Union as such, means in particular the Charter of Fundamental Rights. The European Union has a charter dealing with fundamental rights, many of them being very important for our questions today. In particular, but not limited to, there are fundamental rights to data protection. There is a fundamental right to the protection of private and family life, and there is a fundamental right to property, including intellectual property. So first message on this is, from a European perspective, talking about law of algorithms always means talking about fundamental rights. And the problem with fundamental rights is that in most cases, those rights are not given to someone in an unlimited format, but there are limitations coming with protection of fundamental rights, in particular if those fundamental rights are challenging other fundamental rights. So, for example, the fundamental right to protection of property on the internet might be in some kind of interplay with the fundamental right to data protection, and you then need to outbalance those conflicting fundamental rights. So a lot of European algorithm law means discussing conflicts among fundamental rights, and therefore the first piece of legislation that everyone needs to have a look into, if you want to learn on this in detail, would be the Charter on Fundamental Rights, being part of the so-called primary law, which is from a hierarchical level seen prior and more important and also more enforceable than everything which comes on a secondary law level. Secondary law means everything which is more or less, roughly speaking, day-to-day business, including in particular regulations and directives. The difference between regulations and directives is that a regulation is directly applicable, meaning that if something is regulated in a regulation, this regulation applies in all member states, no matter whether it's Ireland or France or Greece or Austria. A regulation applies as it is. GDPR, the General Data Protection Regulation, would be such a regulation, meaning that GDPR applies as it stands in every single European member state. The problem, however, with regulations such as GDPR is that although they are directly applicable, they leave plenty of room for national legislation, which is not in contradiction with the regulation per se. So GDPR, as example, did not lead to a situation where this is the only piece of legislation dealing with data protection in Europe. There are plenty of European pieces of legislation that are to be read in addition to GDPR, but more particularly, there are plenty of national rules. There are 10,000s, literally speaking, 10,000s of pages of national laws, regulations, rules, etc., in addition to GDPR, that need to be taken into consideration when you are talking about something like data protection in Europe. So although the field is very much European, at the same time, it's also still very national. We are still in some kind of a mosaic situation here, far from a unified legal approach to the topics that I'm talking about. And the third pillar that one needs to take into consideration here is case law. We have a very specific situation here, which is that in national legislations, it's quite normal that, I don't know, the court of Innsbruck has a different opinion from the court of Vienna on a given legal question, and no lawyer would be too upset about this, even if Supreme Courts of a given country are contradicting each other. In many cases, this is not really reason for concern for many lawyers. Different in Europe. When it comes to the interpretation of European law, in particular primary and secondary law, there is just one court being entitled to speak, and this is the Court of Justice of the European Union. This court is really in a unique role here, in the sense of anybody else speaking about any legal problem that has something to do with a European law is not really qualified to do so. because the final and legally binding answer can only be given by the Court of Justice of the European Union. And the Court of Justice of the European Union is doing so in many cases in so-called preliminary rulings, where a national court asks the court about the interpretation of a given problem in a given legal document from the European Union. The big advantage of this approach is there is no ambiguity and there is no case where two answers are given, both of them being valid at the same time. The downside of this approach is it can take literally tens of years between the coming into force of a given piece of legislation and the answering of very important questions. For example, the very, very basic question under which condition something is to be seen as personal data so that GDPR would apply is not fully answered, because it's only the Court of Justice being able to answer this, and the Court of Justice doesn't answer this in a very broad manner, but only on a case-by-case basis, and there are so few cases. So every single question that I'm talking about here today is under review and still under debate. So that's a second, I think, very important specificity of the legal field that I'm talking about here. The first one was that it's very much European. The second one is there is still very little case law. In particular, many of the basic questions are not fully covered by binding answers of the courts. If you want to have a closer look into any of the pieces of legislation that I'm referring to today, this would be the entry point. This is a portal run by the European Union where you can find everything, all primary, all secondary, all court decisions, and also in particular everything which is coming, and everything which is still in the making. The making, by the way, this is also something one should have a closer look into. The making, by the way, is also rather specific in Europe because there are so many different players participating. This is just a list of the most important ones. When it comes to legislation, in particular, number 1, 3, and 4 are important and different from national parliamentary systems. There's just one player being allowed to suggest a piece of legislation, such as a directive or a regulation. This is an exclusive right of the Commission. So whatever I'm talking about here when I'm talking about future trends, such as, for example, the Digital Services Act or the Digital Markets Act or the IAI Act, all these are proposals by the Commission, and they need to be proposals by the Commission because only the Commission is entitled to make such proposals. And it's then subject to negotiation between the Commission after having proposed something, and then in particular the Council and the Parliament, the Council representing the governments, the Parliament representing the people, that finally, hopefully, end up in a joint point of view that finally, hopefully, ends up in a piece of legislation. But this process between the Commission, the Parliament, and the Council can take years. So, for example, the GDPR, which I mentioned already, the General Data Protection Regulation, which most certainly many of you heard about, and most probably many of you still perceive as a relatively young piece of legislation, is already 10 years old in its structure because it was presented by the Commission on the 25th of January 2012. I repeat, 2012, so almost 10 years ago. And the Commission obviously needed quite a lot of preparatory work in order to come up with such a piece of legislation proposal. So in reality, most of the conceptual decisions that we see in GDPR today, which we still perceive as a relatively new piece of legislation, are at least 10 years old. Why is this the case? Because the Commission proposed it in January 2012, but it took the Parliament and the Council more than 4 years until May 2016 to agree on a final version of this piece of legislation. And then there's a transition period in many of those pieces of legislations because it takes time for the member states to adapt to the new rules, which was in this case 2 years. So it finally GDPR became applicable only in May, on the 25th of May, 2018. So this is possibly not really a problem when you're talking about, I don't know, agricultural issues of the law or I don't know, the law of the sea or so, but it is a problem when you talk about algorithms and digitalization and all the topics that I'm referring to here, because here a period of 10 years is obviously really a completely different time. We are talking about 10 years ago. Just to remind you, things like the artificial intelligence or blockchain or the Internet of Things or ubiquitous computing, even cloud computing, were not really yet on the agenda. And COVID, just to come back to this question, Samuel, of course, was not on the agenda either. So that everything which is in such a piece of legislation then is at risk of being outdated from day one. And I think that's probably the third key message that I want to deliver here in a relatively early stage of this presentation. It's a European field. It's a field that is, however, still very much fragmented in national legislations. And it's a field that is constantly at risk of the legislation coming clearly too late, because it takes the political and the legal system so much time to transpose something into the existing regulatory framework, whereas at the same time, the technical development is clearly faster. Coming back to your question, Samuel, about the use of algorithms in emergency times like COVID-19, this is obviously one of the most interesting research fields I've been working on in the last 2 years or so. And for those of you who are able to read German, may I, with all respect, recommend you to Google for my name and Minima Digitalia, because this is a blog that I'm running on the Austrian journal or newspaper Der Standard, where I have plenty of articles about this complicated relationship. Long story short, I think COVID is in a way a very good instrument to make us feel in all brutality, all the deficiencies we have in the regulatory European IT framework, not only in data protection, but also in medical law, and in the interplay between data protection, intellectual property, and medical law. So COVID is thank you, Lucas, for this. This is the link. Yeah. So COVID is nothing as a problem by its own, but it makes a lot of the problems that we are having very, very clear. And the most recent article I wrote for this blog is about QR apps and digital health certificates, which are a perfect example, in my view, for many of the deficiencies that we have here in regulating the use of algorithms. Okay, let me jump over this because this is plenty of information about fundamental rights and their importance. And let's come to the making of the law as it looks when you look at this from a European perspective on algorithm regulation. As I said, it needs to be proposed by the Commission, and the Commission is an animal on its own, which is not one speaker, but there are plenty of speakers, there are plenty of commissioners, and there are plenty of different stakeholders and interests that are united in the European Commission, which is really a strange animal because of the fact that it has so many members, each of them coming from one of the member states of the European Union, but being a member of the European Commission, not as a representative of the member state, but for a given political field. And the problem with this is now that when it comes to algorithm regulation, just like in national governments, it's not that clear who exactly is in charge of this and who exactly should deal with this. So to start with this, just to remember you, for example, the head of the Commission, the president of the Commission, Ursula von der Leyen, has her own view on many of the issues that come with digitalization. In particular, in her first political declaration about her priorities in her office, there is more than a full page on, and I will come back to that page, on how she thinks that digital algorithms should be regulated on a European level. So that would be the first player to consider. The second player would be one of the vice presidents, the executive vice president, Margrethe Vestager, who has clearly in her agenda a Europe fit for the digital age. So that's her priority, to deal with Europe and digital. Then we have, as a third player, one of the commissioners, Maria Gabriel, who is in charge of innovation, which I think has something to do in many cases with digitalization and with education and youth. And last, not least, we still have two gentlemen here to consider. The first one would be Thierry Breton, a French citizen who is in charge of the internal market. And because he is in charge of the internal market, he also is in charge of a lot of the aspects that come with digital platforms, because they, by definition, are addressing a European market and not only a national one. And we have Didier Reinders, who is Belgian, who is in charge of justice. And because he's in charge of justice, he's also in charge of fundamental rights, such as the right to data protection. So when it comes to the reform of GDPR or other data protection related issues, you would also need to talk to Reinders. So at least five, I repeat, at least 5 different people from the Commission, all of them with their own portfolio, all of them with their own agenda, need to be taken into consideration when you think about how Europe can deal with the law of algorithms on a future scale. And things are getting even more complicated if you look then a little bit more into detail into what those people are expected or think that they should do in these fields. So what you see here is just a screenshot. I will not go into any detail, but you will find it in the slides. It's just a screenshot from one of the answers given by Margrethe Vestager in the hearing of the European Parliament on in how far she was planning to go through with a Digital Services Act and with an act on artificial intelligence. And let me just give you a quote for you, one sentence here from Vestager, where she says, given the complexity of the issues at stake, talking about the Digital Services Act, given the complexity of the issues at stake, a wide and thorough consultation of all stakeholders would be required. Any legislative initiative in this area will therefore follow a robust evidence-based analysis and an inclusive stakeholder dialogue. The problem with this robust evidence-based analysis and with the inclusive stakeholder dialogue is that most probably you don't have a robust evidence-based analysis on a moving target like platforms today. Those of you who are working on empirical issues of digitalization will be very much aware of the fact that it's very difficult to get access to the relevant data. And the same is probably also true for the stakeholder dialogue. It's also very, very difficult to address stakeholders who are not constantly joining the political debate, simply perhaps because they are not aware of all those complexities that are happening in Brussels, but still are important for the further development of the environment. So plenty of similar issues coming here, and I could have taken any other of the policy documents of any of the other commissioners, making it quite clear that there is a lot of room for debate and a lot of room for interpretation. Again, just let me mention this spontaneously. If you are able to read German and you want to have a closer look into, literally speaking, one of the okay, Twitter is offline. That's a pity. Then let me Google this for you. Kaiser Online Digital Services Act. Julia Reda. Yeah, here it is. So this is literally from today. This is an article. Let me send you the link to this. This is an article written by Julia Reda. Julia Reda is a former member of the European Parliament. She was there for the Pirates. She has some kind of political science and legal background, and this is her reading of the status quo of the Digital Services Act as it stands by today, after some first negotiations of the draft as it was presented by the Parliament, by the Commission in the Parliament, and her reading of the existing status as it is looking like in the Parliament at the moment is extremely critical, although at the same time she says that this is probably the most important piece of legislation that is going to be expected to come into force when it comes to digitalization within the mandate of this commission. So a very, very critical approach. You might have a look into this. And this is, as I said, because of this. It's because of the fact that the issues are so multiplayer involving, because they are so complex and transdisciplinary, and because it's not only the Commission or not only the Parliament speaking. Yeah, let's skip the court, although I could tell you something about the court, but perhaps I will come back to this, and I will, instead of this, say now that, however, although this is such a complex situation, it's now the third or the fourth commission who has having this, I mean, digital and law as a top priority in their agenda. So when you look into the European Commission's priorities as they look like at the moment, the first one is climate change, but already the second one is digitalization. So it's an absolute top priority for this commission, just like it was a top priority for the Juncker Commission, and the other Juncker Commission, just like it was a priority for the Barroso Commission. So for at least the last 15 years or so, every commission has digitalization as a priority, and every commission therefore puts a lot of effort into re-regulating the framework. At the moment, so this commission now, the von der Leyen Commission, has 10 action fields. And if you are interested a little bit more into the details, you should click on any of those 10 links. And you can expect that behind every of those links, there is at least one piece, in some cases more than one piece, of profound secondary legislation, including therefore either a regulation or a directive on this given issue. So in all of these fields, there is new law and new rules coming, and each of those different fields interact with each other, and each of these fields, each of these actions need to be put into an already existing rather complex framework of primary law and an existing rather complex framework of secondary law, such as I said, for example, GDPR, or a lot of copyright protection regulation that is already out there, or also a lot of rules that we already have in the field of electronic communication or telecommunication, or in the field of platforms and platform liability. So nothing of this is new. Everything that is coming now here enters an environment which is already full of laws. Yeah, there's plenty of background information now, how this in the slides, how this made its way through. And there's also some more information about the priorities of von der Leyen. So this is her political statement when she comes into office in 2019. Worth reading, by the way, having, as I said, one page on digitalization, and having quite some interesting statements in this page, such as this one here. So this is von der Leyen speaking now. It may be too late to replicate hyperscalers, but it's not too late to achieve technological sovereignty in some critical technology areas. So the fourth key message that I would like to deliver probably to you here is, you can't understand European attempts to regulate digitalization and algorithms without taking into consideration that most of the players that are to be regulated by these pieces of legislation are not European or are no longer European. So that this always has an aspect of global trade and of interests of global trade players, such as in particular China on the one hand and the US on the other hand. So whatever is happening in Europe on a regulatory point does have implications for international trade relations, and does also have implication for international trade relation interests. So this is to assume here as well. Hyperscalers, Lucas, indeed means Google, Amazon, and co. So the big players, AGFA, you can call them. So Amazon, Google, Facebook, Apple, and perhaps also Microsoft. So those, right? So the software and data providers that are the main targets here. And at the same time, in the same piece from von der Leyen, she states that it will be important and it will be critical to come up with new rules, because these new rules are part of the initiative or the attempt to achieve something which is called the digital single market. This is also one of the reasons why this is so important for the Commission, because what they want to achieve at the very end is one, let's put it like this, one continent, one law, or at least one European Union, one law, and one single market. So freedom of services, freedom of people, etc., also when it comes to digital. And third remark here, some of the developments are to be seen at least as a challenge, if not to be seen as a threat, including in particular artificial intelligence. So already in this paper, in this governance paper from 2019, von der Leyen was very clear in stating that AI and AI regulation is a priority and is an urgent priority. She will put forward, she said, legislation in the field within 100 days in office. And that's also what she did. However, if you listen to me well until now, it will not be too much of a miracle that although she proposed this in 2019 very quickly, we are still in the process of not even being close to a paper that looks like a final regulation, because this is still under debate both in the Parliament and in the Council, and because there are so different stakeholders joining this debate, that it is very, very unclear what at the end will be the outcome. This is, in a way, the last stage of a development that is much older. So that's the next important message that I want to share with you, if you agree, which is you can't understand these complexities and these deficiencies in the European approach of regulating industries which are no longer in Europe without going a little bit more into the history of IT law and the law of digitalization in Europe. And without going into any detail here, I would like to emphasize that what we see at the moment as the last attempt from von der Leyen and others in 2019 and later to regulate algorithms is just the fifth step in a long history that started at the latest somewhere in the late 60s or early 1970s, when the European legislators for the first time tried to control what's happening with computers. And since then, every 10 or 15 years or so, a new round of this approach starts, and a new round of very similar problems appear. So just 2 or 3 examples of many others that I could give you here. In 1968, when computers looked like this, so this is an image from 1968 that I appreciate a lot because it's for many reasons, but just the most important one here, for my view at least, is it's a huge machine, right? It's a huge machine, not too much of digital to be seen here. It's huge, it's expensive, it's serious. The gentleman looks very, I would even call it melancholic here. And in this moment, when the machines look like this, and so they are expensive, they are run by state authorities, in this very moment, the history of data protection starts. So in the moment when these machines are developed, lawyers enter the scene and they start writing papers like this one here. This is a legal opinion written in July 1971 for the German Ministry of the Interior, where the right to data protection in the German reading, which is the right to informational self-determination, informationelle Selbstbestimmung, is for the first time identified. So you can't think about this without thinking about this, which is you can't think about computers without thinking about trying to get them under control. In 1971, the argument reads just like in 2021. The argument is computerization, digitalization comes with a lot of opportunities, but it also comes with a lot of dangers. And as it's coming with a lot of dangers, we need to get this under control using legal instruments, in particular laws, such as this one. This is the very first law on data protection worldwide, and it was published in Hessen in Germany in 1970. So when computers were like this, already the first law on data protection appears, and a lot of what you know about data protection. So for example, that there should be secrecy and that there should be a protection of personal information and all this. This goes back to a period, and that there should be a data protection officer. This goes back to the 1970s at the very latest, when people like myself were born. When I was then in my teenage years, So in the second stage, when computers were becoming personal in the early 1980s or so, quite the same thing happened again. I hope that you can see this.
Today we celebrate the first glorious anniversary of the Information Purification Directives. We have created, for the first time in all history, a garden of pure ideology, where each worker may bloom, secure from the pests of very contradictory thoughts. Our unification of thoughts is more powerful a weapon than any fleet or army on earth. We are one people, with one will, one resolve, one cause. Our enemies shall talk themselves to death, and we will bury them with their own confusion. We shall prevail.
On January 24th, Apple Computer will introduce Macintosh. And you'll see why 1984 won't be like 1984.
So this is an advertisement that was screened in late 1983. And the reason for this claim, 1984 won't be like 1984, was the presentation of this machine. So a personal computer, meaning that people could afford to buy this and to have it in their living rooms. A personal computer, which was, of course, not connected to anything, but a personal computer which brought computing power into everybody's household, in the sense of that no longer it was this picture, meaning the state running big systems, but it was this picture, which means in every, at least potentially in every living room, there could be a machine. And right in this time again, just like in 1970, when this is happening at the same time on the legal domain, there is happening something really important. In 1983, the court, the German Constitutional Court, identifies a fundamental right to informational self-determination. It says that there is a fundamental right to the protection of, I call it now, privacy, for two reasons. The first one is because it has something to do with your personality and your human dignity. It's important to understand that this right is found in Article 1 and Article 2 of the German Constitution. So really in the core of the legal system of Germany, human dignity and human personality rights. And on the other hand, it's also important to identify and to guarantee this right, because this right is a precondition for the functioning of a modern society. It does not only have an individual aspect, but it also has a collective aspect. The court says persons who assume, for example, that attendance of an assembly or participation in a citizens' interest group will be officially recorded and that this could expose them to risks will possibly waive exercise of the corresponding fundamental right. And this is in conflict with the fact that this would not only restrict the possibilities for personal development, but also be detrimental to the public good, since self-determination is an elementary prerequisite for the functioning of a free democratic society. So it's not only about you as an individual, but it's about us as a collective, why we need this fundamental right in 1983. And then when I was a student, somewhere in the mid-90s, a third technological wave hit the continent. In this case, it came with the internet, and with the internet and plenty of regulatory issues appeared. In particular, the very, very simple fact that if it's somewhere out there on the internet, it's not necessarily easy to regulate this with national laws. So all these statements, like the one from John Perry Barlow from 1996 that you can listen to here, but I will not screen it now for timing reasons. This provocation that came in this time, which is you government of the industrial world. You have no longer any sovereignty where we gather. Your legal concepts of property, expression, identity, movement, and context do not apply to us. They are all based on matter, and there is no matter here. So this provocation led again to the very same response like in the last two cases, so in 1983 or in 1970, meaning lots and lots and lots of legal documents and laws and regulations and cases and so on, in particular, but not only in Europe. And then finally, in the fourth step, somewhere in 2010, Europe started to wake up in the sense of, well, we did a lot of regulation now, but unfortunately, the situation did not change that much. What you see here now, which looks hopefully a little bit similar to what I showed you here, this picture here. So again, you see a huge computer. And again, you see men standing around. So it looks rather similar in principle, the picture, but still it's very different because this is now a picture coming from a Google data center explaining to the audience why it would be a good idea to use Google cloud services if you want to be on the safe side with your data. So what has changed since 1970 is the fact that the infrastructure and the physical connection to the infrastructure has become more and more of a challenge, in particular, but not limited to European institutions and European consumers. It's no longer that easy to control your personal data because your personal data, and personal meaning now the data that you own, is no longer somewhere hidden here on this little floppy disk here or on a hard disk somewhere in the machine, but the data that you want to control is somewhere here in one of those huge data centers. And this situation is now serious in the sense of that even players like the European Network Information Security Agency, so this is the institution dealing with computer security and internet security from a European perspective, has made this a priority problem. What you see here is a consultancy paper from this institution from 2019, describing the European situation as such. You see here a kind of a hamburger. The European Union is the patty in the middle, and the bread is the Chinese/South Korean hardware industry and the US software industry. And there is not too much to regulate left over here in Europe. I quote now, in an increasingly globalized world, Europe has often presented itself as a champion of values. However, the EU's normative power alone cannot guarantee the digital sovereignty, just the same term like the one that von der Leyen has used before, cannot guarantee the digital sovereignty of its citizens or its businesses. To regain its influence and shed its status as an ICT industry lightweight, Europe needs to deliver European champions in the ICT sector that succeed in the marketplace. So that's the challenge now, once again, in this fifth round of challenges coming with digitalization. And I would like to emphasize this argument a little bit more by providing you with some more data that is coming from the Digital Economy and Society Index. That's an assessment provided by the European Commission. So it's official data. It's not a private player offering this. It's an official data set coming from under the responsibility of the European Commission. Very interesting paper on how Europe or the European Commission thinks about competitiveness of Europe in relation to other industry sectors in the world. And this is just one of the many pictures that I brought with me here, but it's in a way typical. So this is the overall DESI score. So the attempt to give a figure for the fitness, the digital fitness of a given area. And the important scores here are the blue ones. This is the top level European Union performing well. This is the average, not so well in the middle. And then in the low end, you have the weakest for European players. So what you see here is two things. On the one hand, you see Europe not as an average, not really performing very well. There are other areas of the world performing much better. That's one thing. And the other thing is you still have huge differences within Europe between the strongest and the weakest players, in particular in the Southeast. And any of the many values that you could use here. I have plenty of them with me. Please look into them if you're interested into this. Any of these values look very similar. When it comes to the Southeast, Europe is constantly underperforming, and the average is not really performing well either. And not even the leaders are world leaders in all cases. Austria, by the way, just one side remark, is not in the lead in any of those categories at all. We are performing somewhere in the average group normally. So what to do now with this situation? The answer, just like it was the answer in the 4 periods before, the answer is again a lot of rules and a lot of legislation and a lot of regulatory work. In particular, as I said already, 2 pieces of legislation, or perhaps 3, are worth being mentioned here. The first one is the Digital Services Act, which is a proposal coming from the Commission from 2020, trying to deal with, I call it now, platforms. You could also say Amazon, Google, Facebook, and others, meaning those providers which are steering our day-to-day usage of the internet in an unbelievable and unprecedented way. And the purpose of this piece of legislation now is to modernize pieces that are from the 3rd wave that I was referring to, in this case in particular from the so-called e-commerce directive, which is from 2000. So the Digital Services Act is some kind of a replacement of the e-commerce directive of 2000. And 2000 was the high period of this internet provocation, this you have no sovereignty where we gather period of time. And the e-commerce directive therefore gives answers to 2 very simple questions. The first one is, which law should apply if a player from one of the countries of the European Union wants to offer its services on the whole continent? And the answer to this is the country of origin principle, saying each player needs to follow the rules of the country where this player comes from, and there shouldn't be any discrimination in any of the other 27 member states, or 26 now. This is a problem when you look into Ireland, for example, because of the fact that many of the international players have their European state place of business in Ireland for many reasons. One of them might be regulation of data protection. The other one might be tax regulation. And all of those argue with very good reasons that they follow Irish rules and that they are not, at least not successfully targeted by Irish authorities, and therefore they should be able to offer their services all over in Europe. That's the country of origin principle that is under pressure here. And the second principle in the e-commerce directive is the principle that there is a distinction to be made between a provider offering third-party content and somebody offering his or her own content, so that there should be liability privileges for providers if they offer other people's content. So if they are working as a platform. These liability privileges, that's probably rather sure, made it very attractive and very simple for platforms or for providers to offer their services in a way that scales very well. If you are YouTube or Facebook or TikTok, the more people willing to join the platform in order to share their content, the more attractive you are, and at the same time, the costs do not really rise. The only factor that is rising is hardware that you need to buy and connectivity. So on the one hand, this allows innovation. On the other hand, it's very attractive for platforms not to deal too much and not to take care too much about what people are really doing on the platform. And we see now again, and in particular, the COVID crisis probably is a very good reason to think about this much more in detail than we did before. We see now again that this is causing a lot of problems because people do not only share nice things on platforms, they share all kinds of hate speech or fake news or whatever, terrorist content on the platform, where it might be a problem to simply stick to the liability privileges that we see in the e-commerce directive. So this piece of legislation, the Digital Services Act, is now debating, and both questions are still open on in how far should we change the country of origin principle, and in how far should we change the platform liability privileges. And no matter whom you ask, obviously you will receive different answers. That's one of the reasons why Julia Redang is so how should I call it? Annoyed. Let's call it annoyed about what's happening in the parliament at the moment. Okay, the second piece of legislation one should take into consideration here is a directive that is already in place, but that needs to be taken, that needs to be transposed now into the national law, which is a directive on copyright protection in the digital market. This is important because it has one rule that you might have heard about, which is about quite the same problem that we had before, now in a copyright perspective, which is about content sharing, copyright protected content sharing on platforms such as YouTube, and this famous Article 17. So Article 17 of this directive tries to end the liability principle coming from the e-commerce directive, making it less attractive for platforms to simply pretend or argue that they don't know what's happening on their platform by introducing liability rules that are stricter. But again, the devil is in the detail because this might, of course, intervene with issues of free speech. This might intervene with startups trying to come into the market that is already there. And it might finally also come into conflict with issues of data protection. And this is just one verbal quote from this article, showing hopefully how difficult this is, because the article does nothing more than stating that whatever is happening as a consequence from the new rules limiting platform privileges for platforms may not lead into a situation where there is something like a general monitoring happening on the platform. And this is, of course, very, very difficult to achieve when you take into consideration the third piece of legislation that I should mention here briefly, which is the artificial intelligence regulation, a very recent, earlier this year, proposal coming from the Vice President Vestager, where she suggests that we should regulate artificial intelligence in Europe more closely than we do so far, in particular by distinguishing artificial intelligence solutions into 4 groups. Group 1, no risk. Group 2, little risk. Group 3, serious risk. And Group 4, unacceptable risk. And in each of those 4 groups, so the higher you get up the rank, the more rigid the rules are, which make it very, very difficult from a legal perspective, in particular, to distinguish between category 2 and 3. Category 2 is still little risk, which means that there are no real obligations for providers of this technology, whereas when it comes to serious risk, there is already a lot of regulatory work to be done. And the only people profiting from this distinction to be made will most probably be the lawyers, because there's plenty of debate ongoing on this distinction. Perhaps it's worth showing you how this looks like in practice. So where we stand here. Now a little bit more in detail. What you hopefully see now here is the proposal from the European Commission on artificial intelligence, the so-called Artificial Intelligence Act, in the database that I just mentioned before, ULEX, which offers inter alia also here an overview about the procedure, where you can see that although this was presented in early 2021, not too much has happened yet. In particular, the Parliament is not yet really fully involved, so that we might expect this to take quite some more time. That's the first thing that I would like to mention here. And the second one is, if you then look into this, into the details, this is all about artificial intelligence and Europe, without but with the little tiny detail problem here that there is not too much artificial intelligence developed here in Europe, and the other tiny detail here, that it is not really clear what an artificial intelligence system at all is. So already the very, very first definition, what are we talking about here when we talk about artificial intelligence, is very complicated to understand, because it means software that is developed with one or more of the techniques and approaches listed in Annex 1. So you need to go into Annex 1, which I will do now for you, in order to understand. Okay, this is not the right way to do it. Let's go down. You need to go down to Annex 1 here to understand what artificial intelligence might mean. But if you go then into Annex 1, you are still not really set, because let me go there. The definition that you will finally find there is the following. This is now the definition in Annex 1, right? So artificial intelligence is machine learning approaches, including supervised, unsupervised, and reinforcement learning, using a wide variety of methods, including deep learning. And then finally, blah, 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 blah. And finally, statistical approaches, Bayesian estimation, search, and optimization methods. And when you're reading this, I don't think that you need to know too much about computer science in order to be able to see that already this most fundamental question, what is the technology that needs to be regulated here is unclear. And I could do the same exercise now with every single one of the steps that I referred to before. So when you look into any of those 4 steps, again, the same questions would appear. What exactly is meant by this, and in how far does that apply? So that I must say that I'm not really too positive about where all this shall lead us to, which brings me finally to the almost very last slide here, which is an overview about some of the cases that you might have a look into coming from the Court of Justice of the European Union if you really wanted to find a legally binding answer to some of the questions of the already existing law. And you might, without going into any detail here, see that that there aren't that many of those cases, that each of these cases comes again with a lot of interpretation issues, and that many of those cases come from periods of time which is far away from anything which is close to artificial intelligence. So even if this act would make its way through the legislation, we would end up in a situation would make its way through in a very precise and proper format. We would still end up in a situation where the rules would need to be interpreted in the light of existing case law of the Court of Justice of the European Union, which is very limited and in some ways also outdated for technological reasons. That's all that I wanted to share with you. I spoke now for 70 minutes, so probably too long. Sorry for this, but I'm happy to answer any question that you might have now. Thank you very much.